All right, ladies and gentlemen, I'm going to go ahead and get us ready. Since this is just a working meeting, we do not have to take roll for a quorum, so we're just going to keep going and right on going through this process. Today, we are pleased to have Richard Burfall, professor, come speak to us from the American Law Institute. I'll let him give his CV, but this is an incredible opportunity for us to hear from someone on a national perspective that can look for what's going on nationally, what goals are, what other states are doing, and some of the principles and some of the efforts, and I'd love for him to have a chance to tell everybody about what he's working on. So with that said, Professor Burfall.
Great.
It'd probably be easier for everybody in the room, if you don't mind, if you could kind of give your CV and let everybody understand who you are and what you do.
Sure. So thank you very much, and thanks for the invitation to be here. I'm Professor Richard Burfall. I teach at Columbia Law School in New York City. I've taught at Columbia for a long time, and I teach courses in various state and local government law, law of political process, legislation, and more recently, government ethics. I was also, as a side gig for 6 years, the chair of the New York City Conflicts of Interest Board, which is in effect, New York City's ethics agency. And just as a comparison to the size of New York City basically has about 300,000 public employees. So which is comparable to the state of Alabama. So we were the agency in charge of collecting disclosure, overseeing disclosure, and the administration and enforcement of the New York City ethics law. In addition, and where the reporter part comes in, is what you're about to see is a kind of a brief summary of the work that I have been doing with an associate reporter, Professor Richard Painter at University of Minnesota Law School, with the American Law Institute, developing a set of what we call principles of government ethics. The American Law Institute is a 100-year-old organization, founded in 1923. This was the anniversary year, focused really on synthesizing, clarifying, and improving the law. It consists of prominent practitioners, judges, and academics. There are about 4,000 members, and they commission projects over the years to focus on synthesizing and clarifying the law. Those of you who may have gone to law school may have remembered in law school seeing things like the restatement of torts, the restatement of contracts. That was the ALI does those are focusing on the common law. In recent years, they begin to come out and look at other kinds of topics that are statutory topics, things ranging from corporate governance to software regulation. And now, in the beginning, about 10 years ago, they commissioned this project on principles of government ethics. And just two more sentences about how it works. And so I, with a reporter and about 25 advisors, people who, again, were academics, judges, practitioners, often people working in government ethics. People were very active. I know one of the ethics lawyers for the city of Philadelphia was very actively engaged, federal judges. We would do some research, prepare drafts, run it by the advisors, get their suggestions, changes, bring it to the senior body in the ALI, the council. They would give comments, critiques, sometimes send it back, sometimes say go forward. And then it would go to the annual meeting where the membership would approve. On the stage we're now in, and maybe I should move towards that. The stage we're now in is all the drafts have been approved, and my associate reporter and I are in the process of finalizing it. So I think you have the summary of the black letter that we've done so far. It's all listed as tentative because it's not final, but it's pretty close to, it's pretty near final. There may be some changes. And again, one more, preliminary statement is the ultimate document is going to be about 200 pages long, and it's like 3 layers. One is this black letter, which is what you've got, which are the more detailed principles. Then there are comments, which explain the terms, explain the ideas, and explain in more detail what we're getting at. And then there are reporter's notes. That's the reporters that my colleague and myself basically give the research, where we got these things from and why they're there. And so the ALI approves the black letter and the comments. You don't have the comments, but we do the reporter's notes ourselves. So that's just a kind of a bit of background to me and the project. I've got about 24 slides. I'm happy to take questions at any time, including before you even get to the slide, but maybe I should just start. This is what I'm going to go through. The purpose of the project.
I think we have our first question.
Okay, go ahead.
Vice Chairman Allman.
I'll make it quick. Just so I like to get the framework correct before my brain starts going down the road. So the principles.
Right.
These are what you produce then are ideas and concepts that every ethics law should either consider. And so they're sort of main ideas. Is that the way we understand it? Yeah. And not necessarily specificity, or it can be tailored?
So they're sort of at two levels, and that's absolutely right. One is at the level of principles. What are the main things? And I'll get to the slide in a second, but this gets some of the ideas. What is government ethics about? What should its goals be? And both generally, and then as we go through what we thought were the 6 principal topics, or 6 principal elements in it, which you've got. And then somewhat more detailed. Not at the level of a model code, not something you take off the shelf and immediately enact. For one thing, the country, this is nationwide, the country is too big and too complicated. Every state is different. Many cities are different from each other. We wanted to have something which could be generally useful, but was probably not going to be something, well, not probably, certainly, you could not take off the shelf and just say, okay, let's adopt it. It's not a model code in that sense. Some parts are pretty detailed and probably could be used that way, but many of it is not. Much of it is not. And so much of it is going to use language which I think doesn't completely pin down and might require much more detail. So we talked a lot about the structure of this. We were hoping for something more useful than the 10 Commandments, as useful as the 10 Commandments can be, but maybe a bit more useful than that. But it doesn't get as granular as you would need if you really wanted to adopt a law. It's not quite detailed enough, I think. But that's right. We had a lot of trouble actually figuring out the level of what we were doing. So that's where we are. So again, the purpose is to advance the principle that public office is a public trust, that the fiduciary idea, to promote public integrity and public confidence in government, to distill, is what we did, to looking at existing federal, state, and local laws and regulations, the basic principles that give our values, to present some operational rules that will vindicate these goals, to give guidance to governments that may be developing or revising their ethics rules, but as I said, not to provide an immediately adoptable code. The variations in needs and circumstances of different places is just too great to have one document that would do all of that. I think I covered this a little bit. So this is where we are. We put out drafts in 2015, 2018, 2021, and 2023. The annual meeting this year was this past May, and we're in the process of revising. I may need to get one more look from the council before it's adopted, but I'm hopeful that there'll be an actual citable document by next year, which you've got. The ALI does make available what they call with a capital T, capital D tentative draft, but with the acknowledgement that it is tentative and can be revised. Again, this gets answering to your question again. The general principles of kind of overarching high-level guidance concerning the principles that should shape the subject, and more rule-like details, although not as precise as what would be found in a code, and with the acknowledgement that specific principles could vary in light of the differences in institutional settings. That we're really trying to cover everything, but recognizing that one size does not fit all in this world. So our first chapter was scope, and again, we were hopeful of applying to both elected officials and their staffs, political appointees, and public employees more generally, and even part-time public servants, people who sit on commissions and public members of commissions, or zoning boards, for example, although the application of specific principles would vary with the nature and responsibilities of the office. We don't apply to judges. I think many of our rules actually fit what judges do, but just about every jurisdiction jurisdiction, judges have their own codes and especially their own enforcement mechanisms. And so we felt, again, I think much of what we say would be totally appropriate for judges, and indeed most judicial codes have provisions like this, but we thought judges are their own thing. We don't address the financing of election campaigns, although that obviously bumps up against ethical concerns, and some members of our group wanted to. I don't think we could, I don't think this is one where you could reach consensus on that, so we didn't do it. And we don't address the regulation of lobbying. Our focus was on the government, the public servants themselves. I mention these two because in many jurisdictions, lobbying and ethics are done together, lobbying, ethics, and campaign finance are done together. There's no right answer on that. There are different places do it differently, but we felt that we could be reach the most internal consistency by looking just at the public servants. And it's not focused on criminal law. And indeed, I think maybe one of our #1 points, certainly for me, it's always been very important, is that ethics principles reach non-criminal actions and can be enforced administratively or through civil penalties. I tend to think of a lot of ethics rules, depending how you want to put it, as either pre-criminal or sub-criminal. You know, getting these rules, these injunctions, these directives to people before they fall into criminal territory, before they do something really serious, and also reaching things which are not serious enough to be treated as criminal, but do raise questions, do undermine the ability, raise questions about the ability of public officials to be serving the public interest. Some of them, of course, there will be criminal law as penalties. I want to say criminal law has no place, far from it, but I think we're trying to refocus to say much of this can be handled through things that are administrative penalties and civil penalties rather than being treated as high-level crimes. So we have 7 chapters. First one was just the overall scope, and then 6 substantive chapters, of which only 5 are substantive, and 1 deals with the administration and enforcement. And so we go through gifts, conflicts of interest, election-related activities of public servants, restrictions on entering or leaving public service, usually called revolving door, disclosure, and then administration and enforcement. The general principle here is that a public servant should not solicit or accept any gift or engage in any financial transaction or financial relationship under circumstances in which a reasonable person would infer that the gift or transaction could affect the public servant's enforcement of official duties. This doesn't require a quid pro quo. We're not talking about bribery. We are talking about accepting gifts in a situation where people might think that would affect how well a public servant does his or her job. It's concerned that the gift or the financial relationship could subtly influence the official's decision-making. The official might say, oh, that's very nice. Of course it won't influence how I do my job. Our concern is that it may do so in ways that even the official doesn't realize, that the human instinct to be nice to people who are nice to you will show up, and that's one reason to impose restrictions on gifts, as well as the avoidance of the appearance of favoritism. So we focus from the general to the specific on gifts from or transactions or relationships with what we call prohibitive sources. An individual, an entity who does business or seeks to do business with the public servant's agency or department, conducts or seeks to conduct activities regulated by the agency or department, seeks or intends to seek official action or to influence official action by the agency or department, or in any way is substantially affected in a manner different from the effect on the general public by the official actions of the public servant's agency or department. We would also include gifts to the spouse or dependent child of the prohibited source. And obviously gifts or to the spouse or dependent child of the public official. There should be no solicitation or acceptance of gifts from those sources, no transactions or relationships with the source unless the terms are the same as would have been arrived at in an arm's length financial transaction or relationship. Yes, a banking regulator can get a loan from a bank. A banking regulator can get a mortgage, even though that entity may have business with the bank, so long as it's consistent with the kinds of arm's length terms that would would be arrived at in an arm's length financial transaction. We don't want to completely prohibit public servants from having dealings, but it's got to be consistent with arm's length. Obviously, there are exemptions for gifts from or transactions with family members and personal friends, depending on the circumstances, including, obviously, the rules that gets tweaked again if the family member is also a prohibited source, or if the person, depending on when that personal friend became a personal friend than was it before the public servant entered government. So we have more details on that. Obviously, these are not the specific principles so much as the captions of the specific principles. The actual principles go a lot deeper, and we have rules that address gifts of complimentary attendance at events, payments for travel, meals and lodging. These obviously are things that come up. People and public servants do get invited to things that may be where it may be a public benefit for them to attend. You may want to go on an inspection trip of a facility in the state as part of your job on doing a safety inspection. There may be situations where these are permissible, but we go through the circumstances when they would be permissible. We also address and try and prohibit, really, gifts and financial relationships between public servants, particularly the problem of the superior and the subordinate. That can also be lead to departures from serving the public interest, as well as ways of creating improper influence on public servants. And we also take up the special question of legal defense funds, which is obviously a public official may be sued for activities relating to the public office. Individuals have a right to defend themselves. Sometimes legal defense is costly. So we talk about the circumstances, how such a legal defense fund ought to be set up, and the circumstances that it can operate, and in particular, who it may not receive contributions from. Yeah.
Representative Jackson.
Thank you. Getting back to the gifts, what are the dollar value of those?
That's one of those situations where we use the phrase nominal, and we would leave that to a community to decide. I mean, some jurisdictions do a flat ban. That, I guess, resolves the question, but it seems like it gets into awfully tricky situations if you're at a meeting and somebody gives you a cup of coffee. So some places have an absolute flat ban on receiving anything from a prohibited source. Others will have some kind of, will use nominal. You could use $25, you could use $50. You have to decide for yourselves, I think, what's nominal in your community. So we purposely do not put a number in. That's part of this not being something you could just adopt. But you've got to figure out, I mean, the basic question is flat ban or just nominal. And then once you get to nominal, what do you think is nominal? And there's no one right answer on nominal. I think if you get up to $1,000, it's not nominal. I think nobody would see that. I don't know about $100. My guess is we're in the $25 to $50 range, probably, but it's going to depend on what's normal in the community, and maybe has to be indexed periodically. We don't have an answer on that.
Is there amongst the states, is there a trend, or is there a different concourse as far as relying on public disclosure of that, to where anything over the $25 or anything more than nominal be disclosed in transparency to the public to have them be able to make that determination?
Yes, I mean, there's both, and I can't say one dominates. I think that maybe the trend has been to move towards prohibition, or prohibition with a nominal exception, but many places also will have reporting, and of course the prohibition would only apply to prohibitions from gifts from certain people. It's obviously not a complete ban. It gets tricky in situations where, you have social relationships with prohibited sources, and we would still you have to make sure what's a real social relationship, and you'd have to think about that in terms of defining who's a friend. But a lot of fancy gifts could show up at your daughter's wedding, and you do have to be careful about to what extent are they true social friends, or is this seen as a way of getting close to the official whose daughter is getting married? I mean, those are the kinds of questions that we have had to deal with, and I think it's probably one where it's probably better to get the rules clearer that it's probably inappropriate, but if you're going to allow them, at the very least, you have to have rigorous disclosure. That is a value choice. I do think the trend has been more towards prohibition, and the real issue is outright, which is in some sense clearer, but maybe unrealistic in terms of completely chilling anything, and chilling people bringing water to a meeting. We don't want to say that that's not going to happen. So you could, we don't have a strong view on that.
Yes, sir.
So you reference, unless I missed it, most of what you referenced, the spouse or dependent child. How far does that go?
Yeah.
Cousins, uncles, parents?
Yeah, on gifts, and it's going to vary, I think, from topic to topic. So in terms of gifts, I think we were looking at essentially that something comes pretty close to the people where if they get a benefit, it's a direct benefit to you. So if your spouse or your dependent child gets a financial benefit, it almost immediately benefits you. Gifts to your brother-in-law may be a little distant, but there might be other situations of conflict of interest where if a more distant relative's business is involved, it might work out differently. So I think we're looking at the assumption here is that you're all in one household, or you're in some sense in one financial package. But you might want to reach more broadly for other situations. I mean, in some ways, the hardest one, and we didn't really do this, but as I've been looking at what's going on in the world now, there's hardly anybody who addresses this, but the question of sort of non-dependent children, about your adult children, but we don't cover that. I think the general rule is spouse and dependent children, or spouse and then it gets closer to what about people who aren't, your significant other. I mean, the laws are the terminology is in flux on that as to going beyond spouse. And so many of the laws are older and use the term spouse, but you would have to think about people you live with. You might want to talk about people in your household more broadly than spouse, because obviously many people have very intimate relationships in which they share finances with people who aren't their spouses. So I'm not sure where we are in terms of our terminology, and sometimes we were careful to expand the scope, and sometimes I think we stuck with spouse. But that's something to think about. But I think here the idea is this is something that where would you feel gratitude, or the kind of gratitude, or the kind of even, let's call it favorable disposition, not even gratitude, but where is there concern that this would create a favorable predisposition to think about the donor if something involving the donor comes before you in your official capacity? And you could decide to make it broader and say, well, you'd feel very favorably if the donor gave something to your sister. If your sister doesn't live with you. I think in all of these things, there's a balance between trying to stick to the principle that public office is a public trust and that public interest should be foremost in the minds of public servants, but not unduly interfering with kind of human existence. Public officials are people too. I don't have to tell you that. And public officials have lives that are not just entirely in public office. So, we want to have good rules, but you don't want to have the kind of excessive rules that not only are unrealistic, but also drive people out of public life. So that's where we draw that line. But there's no absolutely right place to put that line. And if you want to put your parents in, put your parents in. If you want to put your grandchildren in, put the grandchildren in. But I think the idea is, where do we think the danger of getting the sense of gratitude or reciprocity that could influence your decisions is big enough that you really ought to have a rule. And also, of course, public perception. Where do we think the public perception would be? But I'm not going to say that you have to draw the line in one place or the other. So, conflicts of interest in outside activities. A public servant should not use public office for the private gain of the public servant, or if anyone closely associated with the public servant, and we'll spend a little bit more on closely associated. That's the same question, in a way. Who's closely associated? Family and also businesses. if many people have outside businesses. But the family part raises the same question, and possibly you might want to, I think we go for a broader definition of family in this context, because it's not a direct financial benefit to you, but you might still be happy to do things for your more extended family. I mean, it's harder to police the gifts to your extended family. It's easier to police your activities connecting with your extended family. Public servants should recuse from an action that is so likely to substantially affect a financial interest, either of the public servant or someone closely associated with the public servant, that a reasonable observer with a knowledge of the relevant facts would likely question whether the financial interest would influence the public servant's performance of official duties. This is about when you ought to recuse. Obviously, there are situations where recusal may not be possible in some positions, but that is the goal here. And obviously, each of these terms is debatable and requires further elaboration in terms of substantially affect and closely associated. In a government matter affecting the legal rights of specific parties, a public servant should act without bias. This, again, looks more towards decision makers deciding to grant a specific contract, to adjudicating a specific case, bringing in a specific enforcement action. Should act without bias with respect to any party or its representative, and shouldn't participate in the matter if a reasonable observer with knowledge of the relevant facts would question whether the public servant could act without bias, but a prior expression of views about the subject of a government matter should generally not be considered a basis for the imputation of bias. Again, we're talking about if you're a commissioner of an agency that's deciding whether, if you're an official deciding whether to issue a grant, agree to a contract, engage in a procurement, you shouldn't do it if you're biased favorably or opposed to a person or adjudicating a case. But if you've articulated views about a subject, but not about a specific person and don't have a connection to a specific person, that shouldn't be the basis of saying you're ineligible. Specifically, again, public servants shall not participate substantially in a particular matter. I'm highlighting the ones where it's bound to be a debate as to what that means. That he or she knows or reasonably should know is likely to have a direct and predictable effect on a financial interest of the public servant or person associated with the public servant. There should be rules, and again, these apply much more to the executive branch, on the acquisition or retention of certain financial interests. If you are the Secretary of Defense, you shouldn't buy stock in a defense industry. And presumably, if you're the Commissioner of Insurance, you shouldn't acquire stock in an insurance company. Or if you shouldn't own shares in a bank if you're regulating banking. Restrictions on participation in certain particular matters involving specific parties. To avoid bias, we spell those out. We also discuss waivers, because in many situations, the conflict, although a formal conflict, may not be that serious, and the person may be sufficiently important to the job that a waiver might be appropriate even in an individual case or as a general rule. You might, and again, this talks about the role of the ethics agency or the ethics officer within a department of either saying, well, in this particular case, we can set it aside because the conflict is nominal and the need is great and the person has special knowledge, or there might be opportunities to write sort of general rules about waivers. There definitely has to be a prohibition on the use or disclosure of non-public government information. There should be a prohibition on the use of public resources for private benefit of the public servant, a close relative, or other persons associated with the public servant. And that would apply to things like the use of government office and technology, letterhead, equipment and vehicles, office or the government property. You shouldn't be running your private business out of your government office. You shouldn't be using your government computer for your private business. You shouldn't be doing it during government time. Your personnel, your titles, the prestige of your office. You should not be able to trade on the public resources, including the authority or prestige of the office for private benefit for yourself or somebody associated, with some limited exceptions where for government agencies, which also work closely with nonprofits, you might be able to do some work with a nonprofit if that benefits the agency. We have a prohibition on nepotism. This is a pretty standard provision on making employment decisions with respect to close relatives. And again, that goes to, you might want to broaden that to pick up your cousin, even though you might not be worried about gifts to your cousin. So that's why I'm saying these things might vary from subject to subject. Typically, there are restrictions on appearances of someone on behalf of a private party, again, recognizing that many public servants also have outside activities before a government agency or in a proceeding against the government, and restrictions on charitable fundraising, again, should be on your own time, shouldn't involve government resources or use of your official position, and must not target subordinates or prohibited sources. You may be very active, very appropriately active in a community charity, but you basically shouldn't be raising money from that charity at work, even though it's tempting, especially not from your subordinates. There's an improper pressure that comes up from that. I think I got a question. Yeah.
Thank you, Professor. I'm going back to slide 13 here, and I'm asking this from a personal experience that I knew about. Limited exception for certain volunteer services for nonprofits where that serves the interest of the government of the public at large. Now, I have a friend who was a mayor who once enlisted his city public works to remove debris from a building that the World Changers, a Christian organization, had cleaned up, and our ethics commission fined him a little bit of money for that. And is that the type of thing that you're talking about here, or?
No, and I think in the full document it becomes clearer. This really comes out of a situation where there's a kind of relationship between the government agency and the nonprofit.
Okay.
Where the nonprofit, I think if there are a lot of cities more than states have things like the mayor's fund, or there might be an organization where they raise, there's an organization that associates with the city government that raises funds for project. Lots of parks. Many cities have friends of the parks, friends of the city parks. And the Parks Department will work with Friends of the Parks, cultural organizations. In human services, many human services organizations there may be charities doing outreach work for the homeless, or doing things like delivering meals on wheels type things, where they might have a relationship with the city Department of Human Services. And we might want to do, that's what this is really about, that with a proper permission from the city agency, it may be appropriate to raise money for the Community Service Society because they're doing projects that are in some sense city work. That's what I'm thinking of. Not more generally helping out a charity. That would be more the next one, which is, in general, you shouldn't be using resources even to help a charity, unless it's a situation where that entity is kind of so connected. This is really designed to be a special exception because many of us were aware of. It should be fine for somebody in the Parks Department to work to help participate in the fundraiser for Friends of the Parks. That was kind of the idea. And it's fine generally to raise money for charities, but on your own time. And we had too many situations in my agency where people were in effect raising money for charities, totally appropriate charities, from their subordinates. And that seems to be a misuse of power. Or from people doing business, private entities that were regulated by their agency. And that I think is what we were getting at here. The next set of points deal with election-related activities. Public servant may not use public resources to benefit or oppose the campaign of any candidate for elected office, political party, or any organization engaged in the support of or opposition to a candidate for elected office, unless such election-related use of public resources is authorized as part of an established public program for supporting campaign activities. Some states and cities have public funding for elections, or even things like ballot propositions. That would be fine. But beyond that, obviously, public resources shouldn't be used to help out a candidate in an election. And that gets into things like space in public buildings, again, office equipment and supplies, publicly maintained websites, publicly financed communications like Frank Mail, There might be some minimal exceptions for incidental use. Call comes into your office about your campaign. You say, that's great, but you got to call my campaign office, and here's the number. That would not be a problem. That's what we meant. And campaign-related activities include solicitation, receipt, or acceptance of contributions, solicitation of endorsements, campaign work or travel. You shouldn't be doing that from your office or using public resources, or to pay for election-related travel or partisan activities. But we acknowledge that there needs to be some exceptions. When the governor is going on a campaign swing, she can presumably have the security she normally gets. Or if you combine a trip, which is both governmental and political, you can do it, but then you should reimburse for the political part. So I think in general, there's got to be some acceptance of generally this would be the exceptions that's most likely to be occurring for the governor, the mayor, the president, some people for whom the security has to be there all the time. But for the most part, we would say you shouldn't be using public resources to pay for anything election related. Obviously not to use the authority of your office, not to engage in election-related activity during working hours, or in discharge of public duties, or wearing your uniform or insignia of office, and of course not to try to require, improperly influence other public employees to engage in election-related activities. We make some exceptions for elected officials, of course. In some ways, elected officials are always on. Some of these restrictions should not apply to elected officials campaigning on their own time, but obviously it would apply towards campaigning in public places. The last button is a little more controversial, or rather it's more minimal. We basically say our focus on regulating political or election-related activity is only a focus on people, on employees when they're on duty or in a public place or using public resources. So we take the position, and maybe it's a little more nuanced in the real document, that we don't propose a regulation of employee political activity when off duty, not using public resources, or engaged in work for which you're receiving public compensation. But many jurisdictions do, or at least I should say some jurisdictions, and also try and relate, at least for some employees, regulate some off-duty political work. You see this most commonly in communities that want to deal with, say, law enforcement. There may be tighter restrictions on what police officers or highway patrol do, even when they're off duty. Many places don't, but some places do. So our position was we wanted to set the minimum, and we didn't say, consistent with constitutional constraints, because obviously public employees have constitutional rights. Consistent with constitutional constraints, we don't take a position on going higher and being more regulatory. Our focus is really on the misuse of public resources, rather than the concern. I mean, the concern underlying those communities that regulate higher is that this is the way the classical political machine worked, which was, of course, to use public employees even on their own time to support the incumbents, and then they kept their jobs. So our view is it's not crucial. It's not that we didn't address it, but some places do. Revolving door, technically restrictions on entering or leaving public service. The ALI does not like the colloquial revolving door, but I think it's easier to put it this way. A public servant should avoid both the possibility of conflict of interest and the appearance of such conflict when seeking or accepting non-governmental employment. In other words, when you're in, but thinking about leaving. When working for a non-governmental employer after leaving government service, that's the classic revolving door. The last one is something where I think we are ahead of where the law is in nearly every place, but the members of the ALI wanted to go forward, which is also coming back, entering, the so-called revolving in, when participating as a public servant in matters likely to provide direct and substantial benefit to the public servant's former private sector employers, clients, or close business associates. This is actually not a common restriction. The last several presidents have placed this restriction on their most senior appointees, but we thought this was something that was worth getting out for people to think about. So getting more specifically, one set of restrictions deal with while you're working in government and you're looking for another job, or you're being approached you might not be seeking, you might be approached by the private entity that you're dealing with. And, you know, you're in the land use department, and somebody is a developer is there, and they think you're doing a really great job overseeing them. We'd like to hire you. So we basically say you should not, you can't do that, and if it comes up, you should then both tell your employer and recuse from the matter and give it over to somebody else. That it would be improper to seek, negotiate, or accept employment for a private entity directly affected by a particular matter. You're dealing with a zoning modification before the public servant's government, and the public servant is personally and substantially involved in the matter. Then the next 2 points are traditional provisions in revolving doors situations. There's the lifetime ban on appearing before or communicating with your former agency to influence action with respect to a particular matter in which you, the former public servant, was personally and substantially involved while in government. If you handled this matter when you were in government, you can't handle it when you're in the private sector. There are a handful of situations of waivers and exceptions, but it's going to be very rare. This is a pretty strong prohibition. The principal waivers tend to come up with, in effect, you've gone off into the private sector and your old government wants to hire you back on a contract basis. And the government can make an argument that you're uniquely well suited to do this. But that we talk about that situations where you were the chief engineer on some project and you hit retirement and you've retired, you've again gone off to a private construction company and the government thinks we're 2 years away from completion, you're uniquely well suited for this and we will pay you what we were paying you before and not more. So in such a situation like that, and I've seen situations like that, a waiver would be appropriate. So we talk about the waiver process. But in general, there should be a lifetime ban. And then similarly, a cooling off period on any appearance before or communications with your former agency with an intent to influence. Again, we don't really lock into a specific cooling off period. Most places use 1 year, some places use 2 years. Sometimes it varies with the nature of the position or the senior level of the position. There are a handful and a very small number in the federal government which use 4 years. 1 year is probably 1 year or 2 years are the most common. And again, there's usually an exemption for uncompensated appearances in a public hearing, appearance or communication on behalf of a government agency, or appearance or communication required by an agency or court. So if you go work for another government, that's okay. Or if I'm doing this, if I had previously been on your staff and now I'm coming here doing this and I'm uncompensated and it's public, that would be all right too. But the focus is on, because it's a matter of public record, so there's less concern of some kind of behind-the-scenes influence. Revolving in, I'm highlighting it because there really isn't much regulation on this. So this is, I say, we're kind of getting out in front here, which is to talk about, place restrictions that are kind of symmetrical with the revolving out cooling off period and the revolving in basis. Public servants shouldn't participate in a particular matter involving specific parties. That's likely to have a direct and substantial financial benefit for any person or entity who is an employer, client, or close business associate within the preceding year. Obviously, if it's a benefit for you, there's already a conflict. I mean, this is on the presumption that you've divested yourself of all of your interests in your former employer. That would be, if you didn't, that's picked up earlier. This is one where there's the same concern that you might be favorably disposed because of your prior connections, or that other people would think you might be favorably disposed. On the second element, there is some basis of the second element in federal law, which is the disclosure of any special payment made by your employer, the employer that you're leaving when you enter public service. There should be disclosure of that and recusal from participating in any matter likely to have a direct and substantial benefit for the payer. This basically is a response to a handful of specific incidents. Most commonly, if you're leaving a very high-paying job to take a good public sector job. There was one or two particular controversies of people, high-level positions in the financial services industry, leaving to take a significantly lower-paying, although still significant job in the public sector, where the employer, I will say Citibank. I don't think it was Citibank, but I'll just say Citibank for now. Made a nice payment. We would say that really has to be disclosed, and you have to recuse from anything like that. Getting to disclosure. And again, although we're calling it disclosure, I would emphasize it's reporting and disclosure, or the disclosure that we're primarily talking about is reporting to the ethics office. High-ranking public servants should be required to report to ethics officials sufficient financial and other information to identify and deter conflicts of interest, promote confidence in government, and determine whether they are complying with applicable ethics rules. I almost wish I could rewrite this slide to say the purpose of disclosure, which should determine its scope, is to identify and deter conflicts of interest, promote confidence in government, and determine whether public officials are complying with applicable ethics rules. That's really what disclosure is about, is reminding people of the possible conflicts of interest, letting an overseer know about the potential for conflicts of interest, and determining whether you're in compliance. Whether you actually have a conflict, you have to end it. And that's the goal, and so the contents of the reports should be geared to that. Should geared to providing information, including financial information, outside employment, and other commitments that relate to these concerns about identifying possible conflicts, promoting confidence, and determining compliance, but not go beyond that. It should be on entering public service annually thereafter and on leaving. And then the question is both the top button and the bottom button. Who has to do this and what happens with the reports? We basically say that high ranking, we don't define, our definition of high ranking is essentially electeds, senior appointees, and people with some kind of significant decision-making discretion over government policy. Not everybody. In my experience, as I said, in New York, of the 300,000 public employees, I think it was about 12 to 15,000. It wasn't everybody.
That brings up a good point, and that's one of the things that this group has talked about a number of times, is we have so many people that fall under our laws that are not the high-ranking officials that you would be considered. When you're talking the teachers, when you're talking the bus drivers, the police officers, you guys do make a distinction between certain levels versus just the public employee. Right,
exactly.
Okay.
The general rules apply to everybody. The teacher should not be accepting gifts from the parents. I mean, I know it's common in many communities, and maybe if you have a de minimis exception, but there's always the concern of the teachers getting gifts from some parents and not other parents. So we have rules on that. I mean, or the one of the famous case that became notorious is, I think the person who got the contract for trimming trees in the park was giving gifts to the Parks Department. You know, low-level Parks Department employees. Christmas basket. You know, you shouldn't do that. The rule was, we're not going to punish anybody for the Christmas basket. You got to keep it available to everybody. You can't give it to the individual who runs the office. So you couldn't, I mean, that gets to which gifts are going to be prohibited and where, but you can apply the rules all the way down. But you don't have to, but the assumption, for one thing, it's almost unmanageable to have everybody fill out disclosure forms because somebody has to read them. And you probably don't have enough staff to have everybody reading them. We had a skeleton staff to read for the 12 or 15,000 we had. I couldn't imagine having to read annual reports from 300,000 people. So you don't have to have everybody. You have to have some definition of what do we mean by who's high-ranking enough. Elected department agency chairs and agency secretaries and vice commissioners and general counsels. Some things are pretty clear. People involved in procurement almost always. That's obviously one where there's a lot of interest. There's a potential for money. Government money is involved. So there are going to be situations like that. And then beyond that, we also distinguish between reporting and disclosure. Not everything that's reported has to be made publicly available. Obviously, there's got to be redaction for certain personal information, and there might even be a distinction between, even of everybody who reports, you might want to limit the public disclosure of the reports to the people whom there truly is a public interest in knowing about. Again, certainly I think elected officials are always covered, probably commissioners. But you may not need to reach it further down. Or you might have to make it some automatically available, others are available only on request, and maybe put in some speed bumps for making it available. Because I think the key purpose is really to have somebody take a look and see whether there's a problem. And that's really can be done within the ethics agency if it's properly staffed up for that. And what should be disclosed.
I'm sorry, Representative Travis, you have a question?
Yeah, I kind of want to go back, I guess, like these public employees. For instance, if you talked about, we're going to have a Christmas party, sponsor a Christmas party for everybody, like teachers, somebody like that. How would you consider that, if...
I mean, the issue of teachers is really kind of complicated, and it's sort of, maybe I was too quick on that. Obviously, it's quite customary in many places. There is the concern, of course, not every parent is able to afford a gift, and there is the concern that the givers will be, their children will get a benefit, will get treated better than the non-givers. So that's one reason to be concerned about them. You could still have nominal. So if you have nominal, it doesn't get to be a problem. In other words, you allow certain small gifts.
What about like a school, somebody that's a vendor with the school? So.
Yeah, I mean, I guess a gift to the schools would be okay. A gift to the principal would be a problem, right? So, which is why if the gift becomes a gift to the community, or in some sense, or to the entire entity, that's less of a problem, I think, than if it's a gift to the principal, or the gift to, or a gift to the person who's responsible for contracting for food services. That would be a problem. Now, that person might be high enough up to have disclosure. But I'm just sort of talking about it really, the point I was really making, and maybe I wasn't very clear on it, was that the rules will apply all the way down. The rule on gifts could be whatever you think is appropriate in terms of who's restricted and how much. But the rules would apply the restrictions would apply all the way down. The disclosure, mandatory disclosure, I think would be limited to people about whom you and the public are more concerned about. And I'm not sure it makes sense for every sanitation worker to fill out a disclosure form. But, the commissioner of sanitation, the deputy commissioner of sanitation, the person involved with the contract for servicing the trucks, there I think there's probably a public interest in knowing, but I'm not sure there's a public interest in knowing the detailed finances of every sanitation. I mean, more like, I don't think there is a public interest in knowing the personal finances of every sanitation worker or every person or every corrections worker. There is, the case begins to build if it's somebody who's involved in procuring, supplies. For the agency. So I think that's where you have to think about where the line gets drawn. I mean, unless you really want to have a huge ethics agency busily reviewing all these forms, and even then it's an imposition on people to fill them out. I have filled out forms, you have filled out forms. No one likes filling out forms. And there's in some cases it's appropriate to fill out forms. But you don't want to make entering public service even more of a chore than it sometimes is, I think. So I think that's where you have to strike the balance. And you could strike it higher or lower. I'm not saying that it only has to be the governor who fills out a form, but obviously not. But, how far down the hierarchy you set the line is really a matter of choice. But I think it's the idea of figuring out the idea that there is some kind of a line between the people where they have sufficient discretion in their jobs and their jobs have sufficient impact on the public's well-being that it's important to know, and people who don't have a lot of discretion in their jobs or carrying out their jobs and don't have that much of an impact on public policy. They're still subject to the substantive rules, but the disclosure, I think, would be different. So here we're talking about, again, assets, income, liabilities, outside offices, outside employment, gifts, transactions, whatever you think these are the sort of things that we think give information about the potential for conflicts that people might have. They may not be no conflicts at all, but the potential for conflicts. The last thing is administration and enforcement, emphasizing that compliance should be promoted through education and training above all. Most people want to do the right thing, but they need to know what the right thing is under circumstances, and need to know what the wrong thing is. Provide counseling to individuals with respect to specific issues or problems, including informal and confidential counseling, which I mean responding to questions. Can I do this? Can I not do that? Do I have to report this? Adopting interpretive rules and regulations, that's an important thing the ethics agency does. Even when you try hard, it's going to be hard to write statutes that really clearly resolve what a particular matter involving particular parties is, or what directly and substantially involved is, or what a direct and substantial personal financial benefit is. Those are the terms, but they may be something that can be worked out in more detail in specific agencies or in specific contexts as cases come up, and that's something where I think the ethics agency can adopt appropriate rules and regulations, investigating complaints, imposing penalties, and maybe recommending for criminal prosecution. The ethics agency should be somewhat independent of the rest of government, emphasizing somewhat. It's almost impossible to make anything ever truly independent, and there may even be reasons that you want something to be not utterly independent, but to have some ties to the world around it, but it should be somewhat independent. Maybe multiple members, maybe different appointing officers, maybe longer terms or overlapping terms that keep some separation from the political branches of government. There should be whistleblower protection, in case so people can bring complaints free of fear of retaliation. And there should be a range of penalties. I think maybe one of our themes, again, I think I began with this, is to not think of all of these things as crimes, or not think of all these things as crimes requiring incarceration. And these things it's the danger of misconduct, not the actual misconduct. Not every gift is a bribe, or maybe let me reverse that. Most gifts are not bribes, but nonetheless, they raise concerns. They raise concerns of possible favoritism. They raise concerns of possible appearance. So I think, or most, in fact, if you have outside interests, they may not be a problem in certain situations. So I do think that we need to have an array of penalties, including relatively minor ones, civil fines, which don't have to be so minor. I mean, you can have fines that add up in terms of 4 and 5 digits. You can have real fines, administrative sanctions. You could discipline, including censure or reprimand. You can have warning letters when to pay administrative sanctions, at least for first time, as well as criminal penalties. And even thinking in terms of criminal penalties, think about the seriousness of the thing. Is it really is it a misdemeanor more than a felony? And to, in effect, have more of a balance. I also think the less punitive penalties are more consistent with rules that are more fuzzy at the edges, rules that are, along the lines of some of our definitions of conflicts. Don't have an interest, don't take an action which could affect something in which you or somebody associated with you as a financial interest. Sometimes defining all of those terms may be a bit gray. If the penalty is a fine or a warning or a reprimand, it may be easier to keep a fuzzy definition. The more serious the penalty, the more important it is to have a much clearer definition, which is, I think, often hard to do. I think that is all I got.
Any questions from the body? Representative Jackson.
I want to thank the doctor for his opening up some understanding here this afternoon. When it comes to clarity, I'm the kind of guy that doesn't write black and white what the issues are and have it plain enough. So if the person go past that guideline, that they will have repercussions. So that's where we ought to be moving toward as we go forward with the process of legislation. And I appreciate your opening up some guidelines for us to follow. Thank you so much.
You're welcome.
All All right. Well, we are right about the 2 o'clock hour. So that's right about our hour time. Professor, thank you so much
pleasure.
for this. You have certainly given us something to think about. Thank you, LSA, for all your help. Othni, Jimmy, Paula, Casey, everybody for helping set this up and get this together. This will be the end of our learning sessions from the extent of we've heard a lot of from Jimmy, from a lot of LSA, from the problems that we have and how we've proposed to fix them, then how other states now are fixing them, and how the national perspective is on this. So now it's time to start and get down to work. So I anticipate the next time that we meet, we will have a draft of a bill for us to review. It will be a working, I think you called it and I wrote this down earlier, you called it a capital T, capital D tentative draft. So it won't be a bill that is filed through the normal jacketing process that we review. We are going to review a working draft of something that we can kind of take input from everybody on the committee, consider, go through, and I anticipate us doing that sometime in January, and then take those comments to compile those into another final version of a bill, to have a final bill filed by the beginning of February through there. Representative Travis.
I guess question two. The concern, I guess, too, if the bill involves other agents like the district attorneys or something like that, will we have opportunity to get feedback?
Absolutely. We're going. It's not going to be something that I drop on you and say, this is it. So what we'll do is, what the anticipation is, we'll release a version of the bill, and I have no misconception of the mindset. I'm not going to put a lid on it, if that makes sense to you. So when you get a copy of the bill, you're free to share it with whoever you want to share it with. Talk to people in your district, talk to people in your community, talk to people that the bill affects. And you're talking to public servants, you're talking to people that are going to enforce it. Talk to everybody. I want you guys to have the opportunity to vet the bill itself, not just through what you hear, but through what you're able to ask people that you trust and people that you know to look into it into your community. And we're going to take all of that input, and that's why I want to give you a version of the bill and then come back and take after you've gotten a version of it, then come back and take your input and kind of adopt what you've said. You may find problems that we didn't even think about, but I want to adopt those into the bill before we finalize and file a final bill. I don't want to get in a situation where we drop a final bill and then all of a sudden we find these problems, and then we substitute bills, and we're substituting bills at, I know that's been a problem in the past of substituting bills at 11:45 p.m. to be voted on at before 12 a.m. I don't want to do that. I want to have everybody have an opportunity to vet each bill that you give. And another thing that we're going to have, and we've talked about, the bill that we file will not go into effect until sine die of 2025, meaning that if there's problems through there, if there's anybody that has any issues, or maybe we just overlooked something, we have another legislative session coming behind it to kind of correct some of those holes. So no, when you get a copy of the tentative draft, capital D, capital T, capital D, please release it to anybody. Please talk to anybody about it, see what you've got, and let's vet it and do it the hard way. And with any questions, comments from anybody ladies and gentlemen, we are adjourned. I hope you guys have happy holidays. I'm not going to call you back in December. Enjoy your time with your family, and we'll see you guys at the beginning of the year.